It's connecting.
It's this odd gap. It shouldn't be such a
I know it's
lengthy
weird how
gap.
they do it, and then people get let in like chunks. Like it'll go up to 500, and then 800, and then uh, it's weird. It's like, are they actually digitally ushering people in? Oh, see, here we go. Yeah, there's one person right now, according to this.
Yeah, it's often my dad.
Dr. B, how are you?
I don't I think that this one person,
That can't be right. I know. I mean,
two,
I
three, we're up to three. Well, often we schedule this in advance so people have some
no. There's more than three
notice.
freaking people. Do people know? Wait, do people know about this?
Um, I don't know.
Did something go out?
I'm gonna check with the team. I hope so.
Yeah. All right. Well, now it's going. All right. Preet is checking with our technical people. I will see what's happening. There's a very stern looking headshot of Preet.
Oh, it's the headshot.
You look good. You look like George Clooney in Good Night and Good Luck.
So I'm informed by the executive producer that I am live. I know I am live. The question is, come back on camera, Preet. Okay, I'll do that.
This is how things work with
I'm
here at
back on
Cafe,
camera.
folks.
I was getting lectured from the producer. Well, because I thought maybe the notification hadn't gone out because this is the first time we've done this sort of so spontaneously.
Yeah, did something
I
go out?
wanted,
I think I saw an email. Honestly, I get
well,
so many emails now about
I don't
Substack.
really fully know all the ways of the stack.
Yeah.
All
All
right,
right.
so we've got a bunch of people. Elie, how are you?
Good. I am at once shocked and not at all surprised by this
Wait,
verdict.
I didn't ask you about the verdict yet. I
Oh,
just said
oh, how am I
how
in
are you?
general?
How are you?
I'm great. So, I've been really busy lately with work, but I am about to take the first and longest vacation in years. My family's about to go to Switzerland, and let me say, last time my family tried to do this, you may remember this, Preet. We went to
Uh,
Iceland. Well, we went to
yeah.
Iceland, and I realized about 8 hours before my flight that my passport had expired, and
Oh,
so
right.
I did not make it onto that flight.
You
But I
didn't have the juice to get a new passport?
no, I lacked the juice sorely. Someone connected me to a fixer in Manhattan who I was told could work it out for me, and I told him the predicament,
Yeah.
and he's like, "Nothing I can do for you,
Yeah.
man."
Well, I'm glad because you shouldn't be talking about fixers on
um,
live
this
Substack
time we
live.
have checked my passport. I have checked my passport 35 times. It is valid.
Right.
It will get me on the plane. So I'm
Okay.
very excited for that.
Well, congratulations.
How are
Going to a
you?
neutral. I'm very good. I was just trying to waste a little time until we got like a quorum, which I think we have.
I think
I
we have
think
a
we have.
quorum. Yeah.
So the case of the United States of America versus Sean Combs, aka Puff Daddy, P Diddy, Diddy, PD, and Love. Was not aware of all of the aliases or the AKAs. Um, I have not followed this case as closely as I know you have and some other people have. Been following some other stuff at that other court last week or two. He was charged ultimately, Sean Combs, in 5 counts:
Mhm.
racketeering, conspiracy, and then 2 counts each relating to different victims.
Right.
Cassie Ventura and someone whose name we were not told. I guess Jane
Jane.
Doe,
Yep.
Jane Doe. And with respect to each of those alleged victims, there was a sex trafficking by force, fraud, or coercion count,
Hmm.
and a transportation to engage in prostitution count.
Right.
The result, and then I'm going to ask you a bunch of questions about the result taken by the court today, is not guilty on the very serious racketeering conspiracy, not guilty on the 2 sex trafficking by force, fraud, and coercion counts, guilty on 2 counts with respect to each victim, transportation to engage in prostitution. First, before I have a lot of questions about what this means and what might happen and why you think it turned out this way. But before we do any of that, can you explain what transportation to engage in prostitution even is?
It means moving a prostitute across state lines. Like that's all it means.
Yeah. And
It's
that's what makes
very
it a
simple.
federal crime.
Yeah, it's the state line element. I mean, look, you and if I had brought you a case in the SDNY and said this is a guy moving people across state lines for prostitution, I think you would have had some serious questions before you greenlit it. It's really
Yeah.
more of a tack on insurance fallback policy here that prosecutors ended up needing to avoid a complete wipeout.
Yeah. So the question that I get a lot in other contexts, including this context, is what the hell is RICO? Why do prosecutors charge it? why do they say it's so complicated?
Yeah.
There's no one better than you to talk about the racketeering statute, the RICO statute, because as I keep hearing people say on television and elsewhere, this is not the sort of classic and traditional context in which you use a RICO charge.
Right.
The classic context is organized crime. And for those of you who have lived under a rock the last number of years, Elie Honig is one of the great mob prosecutors in the country and was the chief of the organized crime unit when I was the U.S. attorney. So you use RICO in the classic sense,
Yeah.
usually.
Mhm.
Talk about the decision to use RICO here.
I cast doubt on that decision from the start. I wrote a piece for Cafe in New York Magazine before, right after the indictment came down, saying, "I don't know, man. I'm skeptical of this RICO charge." Now, I am not only was I a frequent user of RICO, but I was also very aggressive. I charged RICO. I mean, look, the mob case is an easy, obvious scenario, but I charged and supervised charges using RICO against labor unions,
Yeah,
against all sorts of in corruption cases, and it felt like an overcharge to me heading into the trial. And boy, was it an overcharge! So here's why.
yeah,
RICO means you have to prove not just that a person committed a crime. Usually, it's just did he commit robbery? Did he commit drug trafficking? Here, you have to prove, first of all, the existence of some sort of organization. It doesn't necessarily have to have a neat name like the Gambino family
right.
or MS-13, but some organization with some structural element to it. You have to prove, of course, that the defendant was part of that organization. And you have to prove that in connection with that organization, they committed or agreed to commit a
Yeah,
pattern of racketeering, which means two or more crimes. And here, the prosecutors charged it as the Combs enterprise. And the
right.
crimes were essentially the sex trafficking crimes that you discussed earlier, plus drugs and arson and kidnapping relating to a firebombing. And the jury just wiped that out. I predicted, I was put on the spot last week, and I said, I do not think they're going to convict him on RICO. I said, I do think they're going to convict him on the lower, the interstate
Yeah.
prostitution. And then I punted on the middle ones, which we'll talk, the
So, so,
forcible. Yeah.
so, so so let's unpack some of that a little bit, Ellie.
Mhm.
Um, is there some argument that, because people have asked this question, that there was a legal reason to charge the racketeering conspiracy so as to get the other charges in? I don't know what
Yeah.
that argument would be. And then second question, relatedly, as I laid out the charges, those other things like kidnapping, et cetera, are not separate charges in the indictment. You just
Right.
have RICO, and then you have the two charges with respect to the two victims.
Mhm.
Explain that, and if you think that was a good thing or not.
RICO can really be a powerful tool for prosecutors. And here it enabled them to put in all sorts of evidence that they would not have been able to put in if they had
Yeah,
just charged it as straight sex trafficking. First of all,
right.
you can charge state crimes under RICO, believe it or not. You can basically pull state crimes over from the state court across the street into the federal court. So things like assault. It also allows you to go farther back in time. You're not as constrained by the 5-year statute of limitations. As long as one RICO act happened within 5 years, you can
Yeah,
really go back almost indefinitely. And it's a powerful tool for prosecutors. It's a mix. It's a double-edged sword because on the one hand, it raises the burden of what you have to prove. You have to prove the enterprise, the structure, the interconnectedness, all that. But on the other hand, you're making it harder for yourself. You're giving yourself more work to do and more to
yeah.
prove to the jury. So yeah, it was a
No, no,
case
but I'm sorry, but I
expander.
thought I
Yeah.
thought you were saying on the one hand it's hard
Mhm.
because you have a larger burden because you have to prove the existence of an enterprise and act
Yeah.
in furtherance of that, of maintaining position in that enterprise. But on the other side, you get to throw in a lot of other stuff that
Yeah.
is, I don't want to say prejudicial because that sounds like it's inappropriate. It's appropriate legally. So do you think that's the reason why they did it?
I
The
do.
second part?
Yeah, I do. I think that I'm guessing I'm putting myself back in one St. Andrews Plaza or wherever they are now, and thinking, I think that would have been the calculus of this is going to enable us to introduce so much more proof. I mean, it's not even a given that they would have been able to introduce, the evidence of the guns and drugs that they got in, if not for the
Yeah,
RICO. And so they got in quite a bit. In fact, that'll be an appeal issue, actually, Preet. I'm sure you would
yeah,
expect that, right? They'll say, Combs's team is they're still going to appeal the two crimes, the two fairly minor
yeah.
crimes he
No,
was
of course,
convicted of.
of course.
And they'll say this RICO crime, which ended up being a not guilty, enabled the jury to hear all this prejudicial stuff
Yeah.
about Molotov cocktails and all this stuff.
So people generally have been talking over the last week and in the wake of the verdict about particular defenses to sex trafficking
Yep.
as understood sort of colloquially and among non-lawyers and issues. And so you've been following the trial um, in terms of consent
Yeah.
and the long time relationship. How do those issues of the open question about consent, which clearly the jury must have been hung up on a little bit,
Mhm.
how do
Yeah.
those affect? How does that affect the racketeering conspiracy as opposed to the sex trafficking by force charges?
Right, right. So the sex trafficking by force charges are among the various charged racketeering acts.
Yeah.
But two, I think, really interesting, important strategic decisions made by the defense. The first one was, in 95% of our trials, if not more, the defense lawyer stands up on opening and says, "Here's my client. He's a wonderful human being, and all of their witnesses are sleazebags who are going to lie to you through their teeth." That's not what the defense said here. They,
No,
they stood
no,
up on
they
opening.
didn't.
I thought it was smart when I read it, and the defense lawyer said, Tenny Garrigo said basically, he's a bad guy, folks. He's it. He's done bad things. They said we admit he was domestically abusive of Cassie. You're going to see video of that. They had to because the video. What could they say?
Right,
But
right.
they argued he's not guilty of the specific crimes, federal crimes, with all their jurisdictional requirements and all their intent requirements. He's not on trial for being good or bad. He's on trial for these particular crimes. And then on the consent issue, which was crucial to what I would consider sort of the fulcrum of the case, which is the forcible sex trafficking case. The question for the jury is, did Combs use coercion, force, or threats to get them to engage these two women in these freak offs, right? The extended sex parties. And the record on that was sort of decidedly mixed as to both Cassie Ventura and Jane. On the one hand, they saw the video of him assaulting Cassie Ventura. The defense said, well, that was just a spat about a cell phone. That wasn't about anything to do with the sex acts. And they saw instances and heard testimony. Well, they saw the one beating on camera, but they also heard testimony that he was physically abusive at other times, that he was domineering and emotionally manipulative. On the other hand, the text messages really helped the defense because there were text messages from both victims, purported victims, saying, I'm paraphrasing, but expressing not just agreement to do the freak offs, but at times enthusiasm. And I love when we do these. And at times, Cassie even suggested, hey, why, isn't it time for, they call it FO? Isn't it time for an FO? So the question was, what is the jury going to do? And I could see it both ways. I could see it as you said, well, this is a long term relationship, 11 years for Cassie, a few years for Jane, between adults, intelligent, powerful, self-sufficient adults, and that's consensual. On the other hand, I would have argued, if I was the prosecution, maybe a bit indelicately, but look, if two people in a relationship and they have consensual sex together 25 times, but non-consensual sex twice, the guy's a rapist. I mean, like,
Yeah.
so that would have been. I mean, the prosecution tried to make that case a little less bluntly than that, but the jury found ultimately not coercive, and yes, this was consensual.
Now, did the victims testify?
Yes, the two Cassie testified and Jane testified. It's interesting. I talked to people who've been in the courtroom, and the consensus was Cassie was good and credible, and the jury believed her. But Jane, no. I won't say who, but a friend of mine, a colleague of mine who was in the courtroom, said that Jane came across as a gold digger, and I thought the jury might split the verdict that way, but apparently they did not.
We still use that term?
Yeah, I guess so. But apparently the jury did not fully credit either of them.
But so, okay, on the counts on which he was convicted, right,
Mhm.
about which there will be an appeal,
The two prostitution counts. Yep.
transportation to engage in prostitution, were those, given the facts, virtually impossible to defend against? Like, what was the
Yes.
defense to those specific charges, transportation to engage in prostitution?
I'm not even sure there was much of a defense. And I said in
Yeah,
my piece previewing this for Cafe, I said he's definitely going to get convicted of those. There's no way to beat those
yeah.
because again, all you have to do is show if someone picks up a phone and says, "Hey, we need a male escort at the freak off. Get him here," and you pay him. That's prostitution. And by the way, it's not exactly clear because the indictment
But that's not the
doesn't
prostitution that was
specify.
charged. There's
What's
a
that?
to-wit clause.
Yeah.
You and I know about the to-wit clauses, so there's a little bit
Yep.
of specificity. in count three, to wit, not count, yeah, maybe count three.
Yeah, 3 and
To
5.
wit,
Yeah,
Combs transported, aided and abetted, and willfully caused the transportation of female victims and commercial sex workers. Oh, guess those could have been
that's the
the
escorts.
male escorts, right? In
Yeah,
interstate and foreign commerce on multiple occasions with the intent that they engage in process. So the defense, summarizing what you just said, was focus on the complicated nature of the relationship to knock out or get reasonable doubt, at least, on the force, fraud, or coercion. You
yep,
argue the opposite, consent, and then in a different million different ways, you muck up the racketeering, and you
yeah.
see what happens on the other two, and you live to fight another day.
Yeah, I think that's exactly right. I mean, look, sometimes it's a valid defense strategy to say, we're not going to beat these two low lying prostitution charges. But if we can come out of it with precisely this verdict, convictions on the two prostitution charges, but nothing else, that is a capital WIN win for the defense. So sometimes you do make
Yeah.
that decision to essentially, if not explicitly, concede certain counts. And let me just circle back to the RICO. When I first read the indictment, I thought, okay, maybe they have it here. And I was expecting to see, okay, so Combs set this enterprise up and he had these guys who were his drug couriers. They would bring drugs in and out. And he had these guys who would handle his money and launder his money. And he had this guy who would intimidate people and this guy who would pay people off. It was nothing like that. It was a bunch of, as we would say, mopes, like low lying,
Ropes.
just he didn't have any heavies. He didn't have any real drug connects, of any sort of discernible structural nature. It was just basically Sean Combs being horrible and being helped in being horrible, but it never stacked up as a RICO conspiracy.
You know, it brings back memories when I look at a RICO indictment, because I also did organized crime work when I was a
Yeah.
line assistant, like you did,
Hmm.
and you see, there's always a reference to members and associates of the organization, of the enterprise.
Right.
Who are the members and associates of the Combs enterprise?
It was so the interesting thing is none of them testified. The jury did
Yeah,
not hear from a single alleged co-conspirator. So it was people around him. It was his personal assistants. It was, bookkeepers, but like it was never entirely clear who exactly they were saying was an innocent bystander or just
yeah,
so happened to be a witness or
right.
who exactly, you couldn't say there's his number two, there's his enforcer, there's his money bags guy. They just never brought that home. So that part, I was not at all surprised
Well, it
by
was hard.
the
It was
RICO, but I
hard to
was surprised by
do.
the coercion. Yeah.
Yeah, I was gonna say it's hard to do. Much easier thing to do in organized crime context,
Oh yeah.
because you put on an expert. You and I probably both put on Kenny McCabe, all time, legendary.
Passed before I was there, but I'm well aware of him. Yeah.
Oh, right. Okay.
For
I
me, it
wrote a
was
whole
John
I wrote
Carilla.
a whole
Yeah.
I wrote a whole chapter about Kenny
You
McCabe
did.
in my
Yeah.
book, Doing
Beautiful.
Justice.
Yeah. Yep.
um, and he would testify about the nature and makeup of of organized crime. You could get qualified as an expert. You could have other people who
Better yet,
pled
a
guilty to
cooperator.
being, yeah,
Have a
which you did a
cooperator go,
million
I
times.
was a capo. I started it. We had literal org
Yeah,
charts. Like
to
it doesn't look
say
dissimilar from DOJ's
that,
org chart.
right?
Yeah.
What is the Gambino family? Here's how it was organized. When you're kind of making it up, like you kind of are. I don't mean that in a disparaging way, because we charged cases like this all the time too,
Yeah.
because the law permits it. It's a lot harder to prove that there's such a thing, because it's not really there's no actual thing. There is really a thing called the Gambino crime family,
Right.
but there's not a thing okay. So, what did you think of the quality of the lawyering on the government side? And obviously,
Yeah.
it's our old office. I have great respect for the prosecutors there.
Yeah.
The main prosecutor is someone I hired many years
Hmm.
ago.
Hmm.
What'd you think of their work?
I think the biggest mistake was the overcharging of the case, the way they went about this. I don't fault them for charging the coercive sex trafficking charge. They got an acquittal, but I think that charge, the evidence was there for it. And I think a reasonable jury, you could have tried this case 10 times, and I think
Yeah.
juries might have come back with convictions 5 or 6 times. I think that the RICO charge from the start was a mistake and an overstep. I also want to say this. This is a small detail, Preet, but I want to see your reaction to this. If I had
Oh.
come to you, if I was running, if you let's go back in time, you're a U.S. attorney, and I'm in charge of this case, and I say, hey, boss, so I'm gonna try this case, and I'm gonna have 6 AUSAs at the table, me and five
Oh,
others.
there were 6 AUSAs at the table.
6 Preet, 6. What would you have said to that? You would have said to me, have you lost your
Said,
damn mind? Right?
somebody mentioned to me in passing today that there were a lot of lawyers on both sides.
Yeah, there was 9 on the defense.
Are you sure they were all? Are you sure they're all lawyers, or were there some
I don't know that they
paralegals?
were all sitting physically at the same, but 6 different prosecutors spoke in front of the jury, did, made appearances on the record in front of the
Yeah.
jury. That is
Look,
lunacy to me.
I'm not. Just to be clear on the record, I am not second guessing the office's prosecution, the
I am.
quality of the lawyering. But I will. Well, I know that's your prerogative.
We have different roles.
Um,
Yeah.
but number one, just historically, I can't think of any case where we had. I'm trying to think if
You
there's a
can't
case
sit.
that I can recall where there was four.
Right. I was going to say, I've said on
There's a
air.
max of
Yep.
three.
That 3 max.
When I first came to the office, the most significant case that was tried long before I was U.S. attorney 25 years ago was the embassy bombing case,
Right.
which
Pat
had a death
Fitzgerald and
penalty
those guys.
phase. Yeah, I mean,
Yeah.
really, really great lawyers.
Yeah.
I believe there were only four, and that
Hmm.
lasted months and months, and it involved the death of 224 people at the
Right.
embassies of Kenya and Tanzania.
Hmm.
Yeah, I don't know about the six.
Well, let me expand on that a little. It's more than just like a
If what
nitpick.
you say is true, is what you say is true.
Yeah, no, it is.
Six.
It's more than just a nitpick or a sort of atmospheric thing. In a case like this, a strain of the defense theory, they didn't come right out and argue this explicitly, but it was present throughout. Is everyone's piling on this guy? Everyone's trying to get their moment off this guy. The argument, I'm paraphrasing here, is these victims. All of them were in it consensually for years. They benefited, and now they want a payday. They have their civil suits. They want their fame maybe, but they want their payday. And don't you just sort of play into that when you overstock the prosecution team like that? Don't you just play into like, I mean, there's no way the jury doesn't notice that, even if they're not all physically
Yeah,
sitting at the
unless that's
table
the case.
together at
But
the same time.
someone's. How many people were at the defense table?
Well, again, I don't know how many were there at a time, but 9 different defense
Yeah.
lawyers
So
had
so
some
so
part
may,
of the case, which is
so maybe
preposterous also.
again, we're arguing at the margins about aesthetics, which is not the most
Yeah.
important thing, but they matter. Look,
Yeah.
the ideal scenario, whether you're talking about congressional testimony or in the Senate or the House, or you're talking about oral argument, is the fewer the better.
Hmm.
In particular, if the other side has a lot of people, you want to have fewer people than they have.
Yeah.
And sometimes, depending on, not this kind of case, but if you're trying a big case against a moneyed corporate interest that has, four lawyers at the table, three lawyers at the other table, and like 11 lawyers in the gallery,
Yeah.
and you just got two young um,
Hmm.
prosecutors with integrity and with skill, that's the David and Goliath look, which is, again, aesthetically interesting and good. Not as important as having the evidence or not having the evidence. Now,
Yeah.
you know, going back to the question of the charging in the first place, yeah, you can sort of paint the piling on picture, but you could also take the position, and my guess is this is what happened. You come into possession of this evidence, you come into possession of these complaints, you look at the video, and you see this is a bad guy. So
Yeah.
I'm just spinning out the story,
Hmm.
and he's engaged in all this violence. He's engaged in a certain kind of trafficking that we think we can prove, but it's going to be hard to prove. He's engaged in domestic violence. And yeah, we're constrained and it's difficult for us because we're the feds. But no one else is doing anything about this guy. Maybe because they're afraid, maybe because he's a big deal,
Hmm.
maybe because he's famous, maybe because of you. I'm going to use a line that you will like. If you come at the king, you best not miss,
I
um,
love it.
which is the theme of
Plug
your book,
upcoming book.
upcoming book by Elie Honig, which is great. You should get it or pre-order it if you can pre-order it now. Um, and they're like, we got to do something about this guy.
Yeah.
What's wrong with that? What's wrong with that?
The whoa. Ideally, the case. Sorry, my phone is tipping over.
I've
Okay.
shaken you. I've shaken you with my question.
Ideally, this case would have been charged as an assault case, a domestic violence case by state
Yeah.
authorities. Now, the problem with that is the evidence didn't surface until it was too late, until too many years after the fact. So the statute of limitations
Yeah.
had run. I think feds need to be a little bit careful. They are not. We are not necessarily world universe policemen of all bad conduct. And I get somebody's got to do something about this guy. and he sort of through whatever, Jeffrey Epstein was similar, right? He sort of slipped through the cracks of state prosecutors various times. I'm not sure though. It's an interesting thing to think about. I mean, I never had to make quite these decisions like the way you did as U.S. attorney, but is it your job to think like someone's got to get this guy, someone's got to take him off the street for something, even if it requires a stretch? Now, again, I don't
Well,
think the
look,
sex trafficking charges were stretches, but I think the RICO was.
I'm gonna say with great respect, Ellie,
Yeah.
as I teach in my class at NYU, generally speaking, I'm not saying this occurred with Diddy, but since you brought it up, generally speaking, an absolute sort of pillar of criminal justice is you prosecute a crime, not a person, right?
Right.
So,
Hmm.
so you see there's a crime, or you have evidence of a crime, or a report of a crime. You figure out who did it, and you hold that person accountable.
Hmm.
And I always say, um, with a quasi exception, and the quasi exception is organized crime.
Yes, we've had this discussion. Yeah.
Yes, insofar as you're still prosecuting crime, but the nature of organized crime is such that once you've established over time that there's a Gambino organized crime family, or Banana, or Lucchese, or whatever family it is,
Hmm.
and criminal enterprise it is, and you know where they rank in the organization, member, associate, boss, capo, whatever, there's kind of a presumption that that person does something
Yeah,
unlawful, and then you do, and I'll put this the right way, you and we tried to figure out how to hang stuff on that person. Now, Sean
for sure.
Combs was not an organized crime person, but does a little bit of that principle with respect to organized crime apply here or not?
I guess so, but not in the same way because yeah, I mean, I would always argue for that sort of organized crime exception. You know, these guys, they're avowed criminals. That's their lifestyle. We're
Yeah.
trying to disable a large organization here. I think that argument applies to Sean Combs to the exact same extent that he was guilty of racketeering. I mean, kinda, not enough. You know what I
Yeah.
mean? So I just don't think I think once we saw all the proof, I really don't think I think he's a horrible guy who did horrible things, but the proof was not there that he was a kingpin.
Um, what's going to happen now, putting aside the appeal and the likelihood of success on appeal? The
Yeah,
next question everybody wants to know the answer to is what's he
sentence.
facing at sentencing? Yeah.
Well, so let's start. As we are doing this at 2:28 p.m.,
The 28.
there is a pending motion to release Sean Combs. He's been locked
Yeah.
up for 10 months since September, awaiting trial. And if this was not Sean Combs, if this was an anonymous person, not an unknown, non-famous person, if this was Sean Smith from Manhattan, who
Yeah.
was running his girlfriends and male escorts across state lines to have lubed up freak offs, I think it's a probation case. I mean, there's no minimum. It's a 10-year max. And I think when you look at the
It's a probation case.
guidelines,
Oh, I'm sorry. Yes,
yeah,
now you're talking about the sentencing, not
yeah,
bail. Yeah.
right, right, right. Well, I'm good, but this will circle around to bail.
Yeah.
You're looking at a very low sentence, arguably probation for just a garden variety
Yeah.
or not garden variety prostitution case, interstate prostitution case. Maybe if you want to find certain enhancements under the guidelines, certain things that would raise it up, if you want to find that there was some element of threats or that there were drugs present at the scene, you can maybe bump it up to a year, 2 years, maybe 3 years.
Yeah.
But what the judge is thinking right now for bail is, boy, okay, I don't, judges hate it when they are convinced to lock a guy up before trial and then the guy isn't really
Yeah.
convicted of the top stuff. But there's a real chance he would be in line for what we call a time served sentence, meaning the 10 months he's
Right,
already served.
because
So,
he's
yeah,
serving longer than he would otherwise consent to. Now,
exactly.
another
Exactly.
legal
I would
question.
not, yeah, go ahead.
So he got convicted of these two things, which, depending on the circumstances and the facts found and the judge's posture, may
Hmm.
not get a huge prison sentence.
Yep.
It used to be the case, and I haven't looked at this very recently, that I think it was appropriate for a judge to consider as relevant conduct lots of different things,
Yeah.
and those things could include, which would probably kind of cause lay people to have their eyes go to the back of their head, that relevant conduct can include conduct for which the defendant was acquitted.
That's actually changed a little bit in recent years.
Okay, that
Yes.
seems right to me.
Yeah.
But am I
Yeah.
am, am I am I correct that that once upon a time acquitted
Yes.
conduct could
Yes.
be? which I always thought was insane, even as a prosecutor.
It is
So,
insane,
so,
and yeah.
but so just to pose the question, how does the judge think about all this other nasty stuff that he may believe was proven, not the specific
Mhm, mhm.
RICO conspiracy, but all this other nasty stuff?
Yep.
Can a judge
The
consider
drugs,
that?
the
Will the judge
guns.
consider? Yeah, all of it.
The judge can take one of two tacks on this one. The judge can say, the jury rejected all that. All they found them guilty on was moving people across state lines. That's all I'm going to take into consideration
Yeah,
at sentencing. Judges do that sometimes. They're well within their rights to do that. Or the judge could say, look, I heard and saw all this evidence. My burden is not beyond a reasonable doubt. My burden is just what we call preponderance. Just do I think it's more likely than not? I do think, I do find that he had guns and drugs and that he kidnapped and committed it, threw Molotov cocktails into people's cars, and therefore I'm going to bump up the sentence. Obviously, he's capped at the 10 years per count, and they're going to run together. By the way, they're not going to run what we call consecutive back to back. They're
yeah,
going to be
yeah,
merged into one. And so the judge, if the judge gets into those enhancements, then I think you're look. So let me be a little more specific. Even if the judge says I'm just going to leave it to whatever the jury found and everything else is extraneous, he's walking today because that's a time
yeah,
served 10-month
yeah.
sentence.
Right.
If the judge plans to take into account and punish him for all the other extraneous stuff, then the judge may be thinking of a 2, 3, 4 year sentence and maybe doesn't bail him now.
Yeah, it's interesting, right? Because he's got to, for equitable reasons, even though it's not ripe yet, sentencing won't happen for some months. I don't know if a sentencing date was set, but usually it takes 3 or 4 months for the
3 months,
pre-sentence
yeah,
report to be prepared and interviews to be done and everyone to file their papers. Um, he's got to be, as you say, in the real world, he's got to be thinking about what the sentence is going to be so that he doesn't end up keeping a person behind
yeah,
bars for longer than the sentence would otherwise be. Notwithstanding the factors he's supposed to consider on bail, which include danger to the community and
right,
risk of flight. On risk of flight,
way down now.
well, one could argue. I mean, I'm sure the government is arguing. Well, in some ways, it's more significant because he's 100% convicted. The response
Yeah,
is probably a stronger one, the one that you made, which is,
yeah.
yeah, he's not going to get a lot.
The response is the threat of him fleeing previously was because he was looking at 15 to life. That is
Yes, although that was
nowhere
uncertain.
near.
I mean, the argument is that was
Yeah,
uncertain, and now
yeah,
now there's certitude of the counts. But then danger to the community. Um, I presume the government argued or will have argued or did argue that there's a bunch of people out there who have reason to worry about themselves,
yeah.
and maybe this is a person who is vindictive and feels vindicated and now thinks they can walk tall and exact revenge. How do those arguments play out?
Yeah, I mean that relies on several layers of maybe and
Yeah,
speculation. I think the better argument is he's 55 years old, 57 years old. He's been through this ordeal. He would be insane to start targeting people now. He's still under the court supervision. He's still subject to sentencing, and then whatever his sentence may bring with it. I mean, I think if I was to put myself in a hypothetical robe, I would feel like the risk of danger from this guy to the community is substantially less now than it was before he was indicted. Let's put it that
yeah.
way, for sure. Um, yeah, yeah,
Is there any? So we talked about the local prosecutor, and then I'll let you go.
yeah.
Who in Manhattan is Alvin Bragg, who was a
Mhm.
former colleague of both of ours as well.
Yep.
Is there some chance that, or was there any evidence at trial of a state level crime within the statute of limitations
Right.
that now could subject Diddy to prosecution in the Manhattan DA's office world?
There was nothing compelling. I mean, that
Yeah,
video of the assault was from 20, I want to say 17. So the statute of limitations is long gone on that. So I don't think there's anything Alvin Bragg can do here. Frankly, I don't think there's anything Alvin would want to do here. I mean, look,
yeah,
I mean, the result I understand is unsatisfactory to a lot of people, to certainly the SDNY and to the prosecutorial world in general. But we had a full process here. I mean, he stood up to a very intimidating indictment. He had a fair trial. I don't see anybody arguing this was an unfair trial. I don't see anyone arguing the defense took cheap shots. I mean, look, the defense did a tremendous job here, and this is the process. This is the result. The result doesn't always feel great, but this is our process.
just to end,
Yeah,
the point you made earlier is very important in trials, in political debate, and in life generally. that the credibility you gain in making concessions. I make this point on the podcast all the time. I made this point in my
Yes.
book. Not to make sure that I talk about Trump in every public appearance, but it's interesting that the Trump lawyers, whatever you think of their legal arguments, they never concede anything. And there was, I think there were better arguments they could have made, speaking of Alvin Bragg, in the Manhattan DA case, to say some version, totally different, but some version of what you're saying the defense lawyer said in this case, which is, look, you know, is Donald Trump perfect? Did he manage these things perfectly? And you concede some error, but you hang your hat on, yeah, but this is not a crime to be charged
Right.
in court for all these other reasons. And there's
Right.
something about conceding something that gives you credibility both with the court and with the jury, that this is I think your takeaway from this is that this is an example of that. Am I right?
Yeah. Yeah. Look, I completely agreed on Trump. I'm sure I said on the air and on Cafe. The way I would have defended the Trump case, the hush money case, is did he have sex with Stormy Daniels? Who knows? Doesn't really matter. I wouldn't have said she's a liar. He never touched
Yeah.
her. I would have
Yeah.
said, was she paid off? Sure. Was it to ensure her silence? Again, who knows? But he was not part of the accounting. This is an accounting crime. The accounting was done by these other guys. They even stole from him. He didn't know what was going on. Michael Cohen stole 60. So I would have conceded those various points. But look, sometimes that depends on your client's willingness to
Yes,
allow you
that's a
to concede.
client, as they say, that's a
So,
client man,
client
since I'm
management
back at
issue.
client management issue.
But
If
it's
any
a great,
clients are watching,
you're
you
right. It's a
folks
great
need no
point.
management.
Yeah, exactly. It's a great point, though, just in life in general, in debates, in podcasts, in conversations with your friends. Like, if you can say, I don't die on unnecessary hills. You don't have to fight every battle. And the defense did a good job here of figuring out we can't win this. But we can try to just sort of be precise in what we concede and what we contest. And they succeeded.
My takeaway is that your next book after this one, this is number 3, your fourth
God
book,
almighty. Yeah.
should be titled, and I think it should be a self-help book
Tell
titled
me.
"Don't Die on Unnecessary Hills."
I like it. Don't die on
Well, you
stupid
came up
hills.
with it.
Don't die. People like
Don't
those
die on,
irreverent titles. Don't die on stupid hills.
yeah,
That's
or
actually
low
good.
hills, because that's embarrassing to everyone involved. Um, Ellie, this was a sudden call to you to come and help explain all of this. Thanks for your time,
I'm here
my
for
friend.
you
My friend,
anytime.
congratulations on the book. Everyone, sign
Thank
up
you, Preet.
for Ellie's Substack, and folks, thanks for tuning in the middle of the workday. I love you, folks. Bye.
Thanks, Preet. Thanks, everyone. Great to talk to you. I guess we click off.